Hello, welcome to our podcast. My name is Nicole Enriquez and this is
Diana Bromberg.
And we are from the law firm of Bromberg and Enriquez PC. Please give us a call at 718-714-8542.
We have locations in Garden City, New York, as well as Bayside, Queens, so please stop by. Today we're going to talk about a very interesting topic. It's Social Security disability. So you can qualify for Social Security disability if you have a medical condition that is severe enough to cause you to be unable to work. But sometimes your medical condition may not meet what's called a listing. However, you may still qualify and get approved for Social Security disability if you meet the grid. And Nicole is going to discuss with you the factors and the criteria that is necessary for the grid.
Yes, so there's several factors that the grid takes into account. It takes into account your age, your prior education, your literacy, your inability or ability to speak English, and the skills that you've gained from your job. Once we look at the age category, they break it down into categories of age, whether you're a younger individual, a closely approaching advanced age individual, or advanced age. A younger individual is anyone that is under 50 years old. Closely approaching advanced age is between 50 and 54 years old. And advanced age is 55 to 60. What does that mean? In Social Security disability grid rules, they look at the older individuals as someone who may not be able to transition into a different job if their skills are not readily transferable. For instance, if you're in a highly skilled job and you've learned specific skills to that job, it doesn't mean that you can leave that job and then go into a new job and those skills can be used in the new job. Let me give you an example. We have many clients that are steam fitters, and those are considered semi-skilled jobs. As a steam fitter, there are years it takes for them to learn how to do this very laborious job in terms of piping and fitting and sprinklers, but that is not something that they can use at a desk job, which you would think would be a highly skilled job also. So in that instance, it is not transferable or giving them a direct entry into a sit-down job that maybe they can do. So they look at that and they look at the age and they say, what is the likelihood of this person to be retrained, to go back to school, to take computer courses if for the past 30 years they've been doing labor-intensive work? This is something that we review in our cases and we take a look at it and see how we can fashion and create a way to win your cases.
Yeah, so one of the keys in having the grid work for you is to determine what level of work are you able to realistically do with your medical condition. So if we can prove that you are sedentary or less than sedentary, meaning that you can't lift more than 10 pounds, you can't do repetitive type acts, then we look to see, are you a younger individual? Are you someone closely approaching advanced age, or are you advanced age? So in the hypothetical that you gave, if someone is 53 years old and they are a steam fitter and they cannot do sedentary work and they have a limited education, which means that you have a less than high school education, you could automatically get approved for Social Security disability, even though your condition medically would not be qualifying you for Social Security disability. And you want to grid out, because once you grid out, you're not going to have to come back to be reevaluated to see if your medical condition has improved.
Correct. And in our office, we take a very close look at these factors. And when we present the cases to the Social Security Administration, in order for them to review, we make sure that we know those key factors and we make those arguments. If for some reason your case is denied, whether it's because whoever is reviewing it on the Social Security Administration's end does not realize that your education does not rise to the level that is needed for whatever job they feel you can do, we will then take it to the level of the hearing level. We'll present all the evidence in court. But we make sure to give a complete picture of who you are, what you're going through, so that they can see what your capabilities are, whether it is, as Diana said, in the sedentary capacity, the medium capacity, the light capacity. And that's something that we can explain to you in detail when you give us a call at 718-714-8542.
I'm just going to interject a little bit and give some more detail. When we review Social Security disability files, we do look at the grid to first put you in that category to see whether we can have you approved based upon the grid. When we have the medical condition, we also take the medical condition and argue that you have a listing, so that this way we have both ends covered. So we can argue all of the medical evidence that supports what is a listing, and then all of the information that supports that even if you don't meet the listing, you can grid out. So we make sure that we have a thorough evaluation of your file.
Correct. And we take this very seriously because we understand this is basically one moment in time for you to be able to prove your disability. If you do not win at the initial level, you can have one hearing, and then of course we can take it to the appellate division, but that's a long process. So we take it very seriously at Bromberg and Enriquez, and please give us a call if you have any questions.
Thank you for coming and visiting us on our podcast today.
Thank you.